view that this being an issue with regard to that Valisai and Nuapada, both the subs has been stayed. Your Lordship was proposing to leave the stay order and dispose of the matter. On the question of premises, let the government take a call in between themselves, household, the landlord and tenant. But then, so far as the stay, where the stay order in Mr. Dore's case was passed, your Lordship are taking up that matter. And
there appears to be one more matter
that has become infructuous.
More matter, I think you have.
I had that because that was a case where I challenged the lottery. And
that matter is also listed.
Yes, that has become infructuous because
Which one is yours?
that is 12,000 South. Lakhimpur Resort. The development in that matter, I'm giving the number. The development in that matter, we got a stay order subject to deposit of 50%. He could not deposit 50%.
That is what I really.
So that shop is already placed to lottery and he is end of the matter.
That is item number 59.
WPC 1.
Who is appearing in letters 59? Somebody was mentioning today. Which one?
No, they were mentioning 59 or 57? No, 57.
No, 57. So 59.
Page 14, second from the top.
59
List.
batch of
List.
177.
Here, 1.2%.
Who is appearing in this these matters?
The batch of matters. Several councils are there.
So,
We are there, Mr. Pasri is there.
all of them.
My senior is the principal counsel.
No. The batch of matters, in fact, many of them have become infructuous.
Most of the matters.
So let us today move fast.
Yes.
So that we can reach 59.
The Lord.
And we dispose of equally.
As your Lordship pleases, but
Let us move fast today. Let you
Otherwise, Lordship.
match with my.
or may I
Let
suggest,
you match with my.
definitely we'll try to match your Lordship. Though,
Yes,
though we
just keep
think
it
ourselves.
Passover, we'll take up at.
Otherwise, it give Lordship. Otherwise,
I understood. That is what a view is.
that's
So both of you have been chosen. Now both of you have to find out which way.
Maybe at 4 p.m. so that 10 minutes time will
That is what I really wanted to just know. We don't know 17 matters.
95% cases have become infructuous out of this batch.
I have not read from the orders.
The earlier bench.
50% the amount, additional amount was to be deposited. And certain persons,
They have not been able to.
some persons, they have
Deposited.
100%.
Yes.
One. Only one.
And,
One.
in-
Out of 16 or 17, one has.
Rest were vacation. Rest were.
One, I think you are.
Two of my clients have deposited. Those two will be very limited scope of adjudication. They say that in view of the interim order, your Lordship, the Honorable Coordinate Bench has been pleased to pass that let them deposit 50%.
I understand then what is the issue there, then we'll have to, if you say the issue has now become academic, if you do not proceed.
No, where deposit is there is
only
it is to be decided.
Yes, wherever we have deposited,
It is
we are
to be
asking
decided.
for the interim order to be complied with, saying that we should be allowed to lift corresponding amount of liquor against our deposit. That's all.
That also they have
That's
not
all.
complied.
That will-
Government has not complied to that effect.
That is the only point.
Their adjudication
Will
is
continue. Don't worry, today, I think before rising will definitely.
Grateful.
Yes.
Item number 2.
Maybe the tender matter, which you know, Friday.
The Lordship item 2, the Lordship may kindly pass forward this matter. This is short pass.
Infrastructure facility for Bande Bharat, where the infrastructure facility for Bande Bharat, where there was a particular clause not in the note. Wherever it is required.
Whenever required. Wherever required.
Your Lordship, as the officer of this court, Your Lordship, and being found to bring your notice, Your Lordship, an order of the Honorable Supreme Court, Your Lordship, that squarely decides this issue, Your Lordship. Your Lordship.
There is not a big thing. If the Supreme Court has decided one way or another, that is button on us.
I think I am sprung with a surprise today the particular issue, which was argued by my learned senior, Mr. Mahanti, was not mentioned at all. Now my learned friend
Just.
comes forward and says that this is a Supreme Court. Where is the Supreme Court?
Your Lordship, I'll pass.
He has now given a copy of the order. Now he says it's fully covered.
Your Lordship, if I may, I've created a small.
Yes, yes.
Yes, Your Lordship.
It's not this legal copy.
It's not done. It's not done.
I am also not it.
Your Lordship.
Something was produced on Friday. Now something is being produced.
No, there is nothing, sir. I do not know whether the court is in the scene of the same matter. I do not know. This is the relating to Rashtriya Spark Nigam Limited.
Your Lordship, I'll just clarify that if you, Your Lordship.
Yes, the Supreme Court simply says that Western Railways, they will just sit together and find out the amicable solutions. That's all. Nothing more than that. The Supreme Court has not said anything.
Your Lordship, I'll just show you 2 pages, Your Lordship, it will clarify, otherwise I wouldn't have made that submission.
No. This, I do not know when you are referring this order.
Yes, Your Lordship.
This order does not reveal that there is any law declared by the Supreme Court. There may be some matter relating to, we don't know what is the issue.
Your Lordship, and that's why I've shared, Your Lordship, a short compendium for your convenience, Your Lordship. Your Lordship, if you can come there, at page 4, I had referred to this order, Your Lordship, which you had referred to.
Compendium will.
Yes, so what is this? It does not reveal what is there.
It does, Your Lordship. I'll just take you to the relevant.
Sure. You are showing us
Oh, Your Lordship, I'll first read it out, Your Lordship.
Please.
At page 4, this is the order, and I'll give you the background.
That was.
This order, Your
The party.
Lordship.
First find out the party name.
Yes, Your Lordship, I'm showing it. I'll take you directly, Your Lordship, to page number 22, Your Lordship. Page 21, Your Lordship.
Yes.
Your Lordship, this is a letter which has been issued by the Ministry of Finance dated 6th February 2023, Your Lordship. Alright. And Your Lordship, if we come to para number 3, in the order dated 1
No,
to
that is what is saying that it falls within the scope of our AMRDC or the CD mechanism. That is our alternative dispute mechanism for this. But it does not talk about anything else. Here he says that his technical bid or his bid is rejected at the technical bid stage.
Your Lordship, just to answer the 2 questions, Your Lordship has raised these 2 questions.
What is the
Yes, Your Lordship.
what is this meaning or an impression that I would gather from that note?
Yes, Your Lordship. Now coming to the merits of the matter, Your Lordship. When Your Lordship had rightly pointed out, Your Lordship, if I take you to the specific page, Your Lordship, from the commission, Your Lordship, that be convenient. Your Lordship, in there at page number,
You are representing whom?
I am representing opposite party number 4, Your Lordship. L1 bidder, Your Lordship.
Or
Your Lordship, at page 82, Your Lordship.
what is your law? Sir, is the railway who has to answer us.
Your Lordship,
Who are you?
Your Lordship,
You may be a beneficiary, but no.
Your Lordship, if I may, if Your Lordship may indulge just 2 minutes, Your Lordship had rightly pointed out the 2 questions. I'll take you to 2.6 and this page, Your Lordship. At page 82, Your Lordship.
No. You can see.
Yes, sir. Page 82, Your Lordship, and I'll just repeat it. It says,
Repeat because he has already read.
yes, Your Lordship.
There's no bullet point.
Wherever required, comma, the bidder should submit for verification
Yes.
the extract of the charter documents and the documents such as the board of the shareholders resolution,
Right.
oblique power of attorney in favor of the person executing this power of attorney for the delegation of powers hereunder on behalf of the bidder. 82, Your Lordship, I'll start reading it with page number 47, Your Lordship,
Yes.
2.11.
Yes.
Are you there, Your Lordship?
Sure.
Heading, Your Lordship, documents comprising technical and financial.
No doubt. They
Now,
have record.
2.11.1, most importantly, Your Lordship,
Yes.
Para 2. The bidder shall then apply for the RFP, so and so, by submitting the documents mentioned below, along with the supporting documents, which shall comprise of the technical bid, and then at B below, they have mentioned about as per format and appendix.
Are they specified the supporting document in B? Once they have specified a supporting document in A, are they not supposed, what does it mean? If they have specified in a subclause, supporting document means that A has to be supported by a document. If it is conspicuously absent, then the question of cancellation will come.
Your Lordship is absolutely correct, Your Lordship. When it is conspicuously absent,
Conspicuously absent.
in
Then
your
principle, the doctrine of cancellation promises will come.
I
And then
agree,
if I read conjointly with 81, 81 does not contain at the bottom that what should be the enclosures.
correct, Your Lordship. For that, I'll bring you to 2.6, Your Lordship. Can I bring you to 2.6? It was relied by
referred everything.
at page 44. Yes, Your Lordship.
Sure.
Yes. 2.6.1, Your Lordship.
Yes.
The authority reserves the rights to verify
Yeah.
all statements, information, and documents submitted by the bidder
Correct.
in response to the RFP, and the bidder shall, when so required by the authority, comma, make available all such information, evidence, and documents as may be necessary for verification.
True.
Your Lordship, such documents in this
No, I
context
understand.
relates to the documents that submitted at the time of the bid. Yes,
Sir,
Your
I
Lordship.
am conscious, sir.
Yes, sir. Yes, sir.
But again, I am saying,
Yes, Your Lordship.
even the authorities have said that the supporting documents have to be done, then why the authority did not include the word supporting documents in B? Why was included in A only?
Now, Your Lordship, if
Why A?
Your Lordship,
That shows that the authority does not want, because I am reminded of the Nazir Ahmad's case of AIR 1936 Privy Council. It says that when it is said that it has to be done in a particular format, then it has to be done in that format and no other format at all. And the B says power attorney should be in the appendix 2. Appendix 2 at page 81 does not say any document to support. But the note appended thereto says that if the authority want any document for a verification, just to verify whether there is an authenticity or a genuinity, what you have said, he can call for you and you are bound to produce those documents. What? For what? For verification.
Your Lordship,
The word is verification. Have you asked the railway a single document, a letter, or a correspondence, email, SMS, WhatsApp, that you please produce the power of attorney, the board resolution, whatever you have in your support, give it to us.
I have just one responsibility. It will clarify, Your Lordship. Your Lordship, 81 and 82 form part of Appendix 2, Your Lordship. That you will agree on.
True, that is why I
So,
say.
Your Lordship, notes are forming part of the Appendix.
True.
So, Your Lordship,
Then what is the meaning? I do not know. My English is very bad. Wherever required. What does it mean? This word connotes what? Meaning, I do not know. Wherever required. Now, there are two things. Two way of interpreting. I am conscious. Wherever required means requirement under the general terms and conditions or the terms and conditions embodied in the document. There will be one way of looking at it. Second way of looking at it, wherever means if the authority wants any document to be produced, which is not mandatory in terms of the clauses, then he is bound to produce those documents for verification. These are the two interpretations. Then we have to find the intention. What are the supporting documents? Because the supporting document is important. If in one clause the authorities have incorporated along with the supporting document, and in another clause it omits the word supporting documents, then what impression one can have from those? That means to that aspect, no supporting document is necessary, but if the authority wants supporting document, you'll have to put.
Your Lordship, if I may clarify that, Your Lordship.
These are the two interpretations
Yes, Your
one can have.
I'm grateful, Your Lordship, you've come to this point, Your Lordship.
No, that is.
Yes, Your Lordship.
Give me a third interpretation.
Yes, Your Lordship.
I know you will be arguing whenever required means required under the terms and conditions of the bid.
I'm not arguing, Your Lordship. It is what it is saying, Your Lordship. I'll take you to 31, Your Lordship. 1.2.9, Your Lordship. I'll give you context to it, how it was, the RFP is there. 1.2.9. Page 31. 1.2.9.
Page?
Page 31, Your Lordship.
Yes.
Are you there, Your Lordship?
Yes.
Any queries or requests for additional information concerning this RFP shall be submitted in writing by speed post, courier, special messenger, or by email through so and so as to reach the officer designated in clause 2.11.4 by specified date. The envelopes and so, and then there is a queries request for additional information, RFP for setting of infrastructure. It is not the part of the petitioner, Your Lordship.
That is relation to if they want any clarification or additional document, then they have to do it.
That
It is not the authority's reverse.
correct, Your Lordship.
What-
Then Your Lordship, 1.2.9 has to be read with 2.16 and 17, Your Lordship. This is
What
about
does it mean?
confidentiality. Your Lordship, 2.77, if I take you, Your Lordship, straight to page 50, Your Lordship, 2.18 and 2.19, Your Lordship.
Yes.
2.18, confidentiality. Shall I proceed, Your Lordship? Just, Your Lordship, just 2 minutes, Your Lordship. Information relating to the examination, clarification, evaluation, and recommendation for the bidder shall not be disclosed to any person who is not officially concerned, so and so arising out of the bidding process. The authority will treat all information submitted as part of the bid in confidence and will require all those having access to treat the same in confidence. Authority may not divulge any such information unless directed to so by a statutory entity that has the power under law to require its disclosure or to enforce or assert any right, privilege of the statutory entity and or authority as may be required by law or in connection with any legal process. 2.19 correspondence with the bidder. Save and except as provided in this RFP, the authority shall not entertain any correspondence with any bidder in relation to acceptance or rejection of this bid. So, Your Lordship, at this point, at one end, I am limited. Right?
It's a very interesting. The moment the authorities have committed constitutional violation, discrimination, arbitrariness, then nepotism, the favoritism, no correspondence in this regard from a bidder will be entertained. Very nice way of interpreting, I accept. Where is why the High Court will be burdened? Absolutely correct. No should be, High Court should not be burdened. Why it will go? Authority is paramount. Sacrosanct, their decision has a, I would say, the shield not to be broken.
I bow down, Your Lordship. I wouldn't press on that.
What are you talking?
Your Lordship, you mentioned arbitrariness. Now, my position is,
Question is, sir, is the question of arbitrariness will come when the authority themselves have not adhered to what would discern or appear from the terms and conditions. If the terms and conditions are capable of two possible interpretations, if one has been adopted by them, then can you say that they are at fault?
Your Lordship,
I'm asking you. I'm bringing that concept of a contempt. When an order is capable of two interpretations, then if one adopted will not come as the contempt side. Similarly, if they perceive this word to in a particular manner, and which cannot be said to be absolutely arbitrary, which cannot be said to be absolutely unreasonable, then why not? It's a fair and transparent way of participation. You are not a favored one. If you fight to the nail, then an impression is otherwise.
Your Lordship, if I may
Then
clarify.
the impression is otherwise.
My
And
position.
they are not a private individuals. They are also a government company. They will definitely, when they have come up, they will definitely show. It's not that their personal interest in the war. No. It's a government company, it's a public company.
I'll clarify my position, Your Lordship.
You
I
are
am
a
opposite
JV.
party 4.
You
I'm
are a
joint
JV.
venture 70%.
You are a JV, sir.
Your Lordship.
You are a JV.
But I'm 70% equity holder, Your Lordship. It's on
JV.
Your Lordship, just to
What are
answer on the question of wherever required, Your Lordship, had
Let them have the openness in this regard. That's not it.
Your Lordship, just last point, Your Lordship. There is no difficulty, Your Lordship, in terms of the.
I think I am privileged. I am honored. I am more insulated when I have the companion judge sitting with me and Mr. Raman, Justice Raman. You are throwing and hurling one paper without looking into what it transpires. But some observations which is absolutely different in a different context, you wanted to rely. My brother has found out that from which order that SLP originate and what was the subject matter in that particular case. That was a claim of a refund under the railway claims.
Correct, Your Lordship.
And my brother has even downloaded that particular judgment, which is under challenge by a division bench presided over by Justice K.S. Javeri and
Right, yes, Lord.
Justice G.V. San. So that's why I feel very safe.
Your Lordship.
Sir, don't try to mislead the court.
Not at all.
Don't try to create an artificial confusion that one order observation of the Supreme Court out of the context you are referring it when we can't comprehend that in what context this observation has come. Now we got that in this context the observation has come. And the Supreme Court, I would not say anything, has said that you will have to sit and sort out the problem relating to refund.
Your Lordship, only on the defense, Your Lordship. It was
Sorry.
not on the point of
Sorry.
MRCD, Your Lordship. On the merit.
This argument has been advanced by
I have already concluded the last day.
Yes.
Again, only I am raising this on repetition. What I have said, I am not going to waste the time of the court. The only reference I have given once again, my lord, is section 3, page 53.
Yes.
And that the clause 3.1, evaluation of technical bids. We here the petitioner rejected on the technical bid only. That's why I will say that other part what nursing has invited, we will get away nothing to say and we will maintain transparency.
Yes.
As regard to 3.1.61 is clause is concerned the test responsive. That is the clause, subclause D, the power of attorney is uploaded on e-procurement portal. It is specified in the technical 1.25.
Test of responsiveness.
Yes. As regard to flexibility,
First step towards the evaluation of the technical bid, you are referring this.
yes.
You are referring this clause.
D.
3.1.6.1.
1D.
No, I'm reading as a whole.
Yes. Yes,
The
sir.
first step towards the evaluation of the technical bids, the authority shall determine whether each technical bid is responsive to the requirement of the RFP. No problem.
Yes.
Its technical bid shall be considered responsive only if bid is received online, including annexure 1, whatever is there.
Yes.
All documents listed in clause 2.11.2 are received physically within a time as mentioned in clause 1.3. Correct. Technical bid is accompanied by a bid security as per this clause. Power attorney is uploaded on the pupils as specified in clause 2.1.5. So power attorney in that format, if they have submitted in a format, the technical bid is accompanied by power attorney for lead member. That is not a case because they are not a
Not
consortium.
our case. Yes.
They are not a consortium. So there is no difficulty. D is very important. And this is the 2.1.5.
The bidder should submit a power of attorney as per the format at appendix 2, authorizing the signature of the bid to commit the bidder.
That is 2.1.5.
He has not filed in this format, you are not disputing. That is not the reason for rejection.
But what I was saying,
Thank you for inviting because this is the additional support I got. Mr. Kaur has not invited.
so why I am electing so
Last,
No, you have not invited this clause.
no.
Yes.
Yes, that's why in the time of filing counter, where paragraph 6 as well as paragraph 21 and 23, we describe this that this was the issue for which we are not, his case has been rejected on the technical. Only this point we have, otherwise, if anybody will come and we are eager to do the work as soon as possible.
I seek your apology, your lordship, if there was an impression for misleading your lordship. But page 9, your lordship.
I tell you very frank, when you do not know that in what context this observation has come, then I believe it is the first and foremost duty of the member of the council to say that if this matter pertains to this dispute, this was the fact, this was an emergency, because then the Apex Court has observed this, not in that blanket manner, and then say that this is not properly.
I apologize, your
You
lordship.
really wanted to postpone the hearing. If you wanted to postpone the entire issue, then because the Apex Court is insisted of the matter.
Not at all. Not at all, your lordship. Just, your lordship, the compendium I gave at page 9, your lordship, it said Ministry of Railways.
In order,
Yes, your lordship.
this is final nature.
Right.
That can be relied upon subject to the facts are similar or identical and the provisions of law
Correct.
are also pari-material. In that context, we can refer to or reliance. That is,
I apologize again, your lordship.
you have submitted an interlocutor, not final.
Your lordship, the matter is still pending, your lordship. I apologize.
When this is 7 judges, Honorable Supreme Court,
I apologize.
you should not have. You should not have.
Your lordship, the context is only page 9, your lordship. That's all, your lordship. Because it says Ministry of Railways and subordinate authorities are bound by MRC. That's all.
The interim order may kindly continue.
My lord,
That was the
is
objective.
disposing or?
Hearing concluded.
Yes.
There was an objection raised.
We are eager to.
There was an objection raised that
start
the bank guarantee is
Whoever
start by the opposite party number 4. It's not a correct fact. The bank guarantee is still live till August. Till August because
We didn't plead it.
you have
Concentrate on a
Our
technical.
extension validity is there, your lordship. We have extended our bid.
We do not want to go into that aspect. We will squeeze our consideration whether the validity is.
Lord is
there or not.
complete, Paramount, term one.
Technical man.
Yes.
Grateful.
It's not there in the report.
Yes.
Yes.
Know the names?
Item number 3.
Item number 3, that HPCL IUCL dispute. That will impact and in the requirement of an interim protection. Otherwise, that's the reason I have been.
Vigilante was served at.
Vigilante I am not pressing for the moment. Vigilante I am not pressing for
Sir,
the
it
interim.
was served in home yesterday.
Night 11 o'clock.
He served me counter on Friday.
Time in the morning to the.
Today morning only I got.
No, not.
Anyway, since my learned senior is not pressing, I am not insisting. Before your lordship passes any order, I would like to bring to your lordship nation, there are 2 other writ petitions on the same issue pending.
How can it be the same issue?
I am just praying, my lord, your lordship.
How can it be
This
same?
issue, I think, we
It's same
decided in our
NOC,
petition.
same NOC, my lord.
So,
No, it's.
sir, we decided in one writ petition that it cannot be done. Now the, I would say the result was that now since you have awarded, you have cancelled it. Now they're challenging a cancellation.
Yes.
They are
Similar
taking that because of the
earlier order.
the earlier litigations having pending before the court, and the court ultimately held that this is unreasonable, this is not permissible, and then in that event.
On that context, 2 other writ applications are pending.
So that's not the issue. It's not very issue. Maybe
I'm
some
just
other.
trying to bring to your
Let
lordship.
me place one list of dates, but kindly see what is, that is what has
I'm not
happened.
trying to mislead one.
In a 5 minute, your lordship will grab the whole.
I'm just saying, your lordship, before passing any order, take note of this 2 writ applications.
So it's not between the same party. So kindly take up my list of it in 4 pages.
Pertaining to the same tender, same issue.
They are saying no obligation in participation of these cases in other, there is no condition.
No condition at all. They are rewriting the NOC and saying that from their side,
Yes, that is there. And then where is the rejection?
rejection is annexure 1
Page 18.
page 18.
Rejection of
No, rejection of the bid.
Submitted a conditional NOC from IOC.
Yes, the same ground.
Should I read it, man?
Suraj, kindly see page 21.
That,
Page 21. Yes.
Please.
Page 19.
It starts at 1800. 19. Correct. Then is 19 last.
So there was, this is not a condition that the moment you become successful, they will release it. It's not a conditional in there.
19 last five. Yes. Page 19.
Unconditional. Very good loss 6. But why you are can you do it without at the time of participation, you have already submitted this particular
Yes. It was along with the tender paper.
thereafter they adjust you as the
Yes. Yes.
So it is really going back to the stage of
Exactly. How can you?
why you allowed him to participate? Let us read 1 minute. Why you allowed him to participate in the when you were aware that this particular certificate which they annexed at the time of submission of the bid is a conditional one. Can you do it? Why you proceeded on that?
At the time of injection.
Why you proceeded? Why you proceeded on the why you proceeded to open the price?
Issued me LOA. Issued me LOA.
Required to be
Why you issued it?
at the time of induction, at the time.
Have they suppressed the fact?
No.
They did not.
No, sir, page 18. Subparagraph. At the time of bid submission, as per attachment 11 of the final.
This is
You
not
had
taken.
declared, just 7 out of 12. You were already in operation, so you submitted a conditional NOC from IOC.
So the NOC was given to you. Then why you allowed it?
That is the conditional NOC. Let us go to the.
Sir, please try to understand what is troubling us. If this is prohibited under the general terms and conditions, you should have rejected their bid at that stage itself.
Threshold.
At the threshold. But you did not. You proceeded, qualified him in a technical, you proceeded, qualified in the financial, you proceeded to issue a LOA as well. And then he intimated that because of that,
IOCL is not releasing.
they are not giving or releasing it. I am unable to do. They came before the court, final rate. You were there, present.
Yes.
Yes.
You were there, present. Everything has been done. Had you cancelled earlier that I can't wait eternally, I could have appreciated this. But after the judgment is there, then can you proceed
To that,
to this?
to that I have a reply page 111, my lord.
What?
That is the relevant clause. NOC to be submitted at the time of induction of the tank trust.
So this is what LOC does not say conditional or unconditional,
That is there.
qualified. And this does not appear to be a conditional one.
You also may see the entire the tank trucks under operation with any other oil company and unconditional. This is what I am trying.
Correct.
No objection certificate.
This is what our objection. Where is the condition?
Yes,
They
sir.
say,
Your Lordship may see the-
sir, please understand what is the condition. They say, yes, we give you a no objection certificate.
Yes.
You can take the tanker,
Yes, my lord.
provided you become successful there. Only thing
Subject
is
to replacement.
no, sir.
That's there, my lord.
That's whatever. So they have already, the moment they become successful, they offered them the higher capacity of the tanker.
Yes, ma'am.
Then some dispute arose.
Yes, ma'am.
So this cancellation subsequently was found to be wrong. That means it has to be there. They have placed it.
Yes, my lord.
How can you proceed a conditional one or not?
Then your Lordship may see what Chopin's reply in the impugned order he has given. He has not given the transport vehicle which has been released by IOCL on that day. That is there, my lord.
They don't permit us. How do I give? They are cancelling my LOA. Now I have got back the
At the
vehicle.
time of filing of Chopin's, my lord. Your Lordship may come to the impugned order. Page 19, my lord.
What is the ground for show cause?
Page 19, your
Same on unconditional LOC.
That's all.
Yes, that's all.
Can you go beyond it? I'm talking law. if you have issued a show cause notice citing a ground, can you go beyond that ground? Only ground was, is it a conditional or an unconditional?
That's what-
That's all.
Yes, madam.
Can you go beyond? They have
My
not placed
submission-
it, they have placed another, can you go and take that plea?
My submission.
That is not a show cause.
My submission would be it is an unconditional, conditional NOC.
Correct.
You will also
That's
cannot
only
accept.
interpretation,
Huh.
nothing more than
Yes,
that.
ma'am. And it is the
And you
second,
cannot deny that you proceeded with this bid, issued everything.
and to that reply, I have said that at the time of induction, he is supposed to file his NOC at that time, madam. And your lordship may say it is, look, it is 19.
At the threshold, had this been the reason to.
Tender terms are
Yes.
looked at that time. Your lordship may see page 19, my lord. Page 19 in compliance to order what Sukar's reply he has submitted. He had the two trucks from what awaiting release from the IOCL, and he has submitted rest 3 trucks, my lord.
Sir, that may be, can you go beyond your show cause? You are concerned with your show cause is only in relation to a
NOC.
NOC, that's all.
Yes, madam. That would, my submission
That's all.
would be at the time of induction only.
That's all.
That is required.
Nothing more than that.
And
You have
second
to
is
see
that
whether
this is a conditional.
this certificate can be said to be conditional or unconditional in what
Your
sense?
lordship may decide.
What is the meaning of the word conditional? Where is that clause?
You know, that is, NOC is
NOC.
page
111.
111,
111. 111.
page 111.
Clause 6. मुठिया चांबर दिखेगा
Yes, madam.
Clause 6.
Yes.
And your lordship may see the page 274, his NOC, madam.
That he has referred. Tell your letter, after this judgment, they have cleared, where is your letter that you have placed?
It's 298.
Yes, you are placing these two trucks.
Yes.
It's 298.
Two,
Page
98.
307 is your representation, it seems. 307 and representation.
298.
307 is after cancellation of LOA. After cancellation of LOA. But 298 is reply to the SOCOS notice.
No, that is, I am not on.
placing those two vehicles. My lords are asking about placing those two vehicles. In fact, those two vehicles were released by IOCL.
After filing of local.
Whatever.
But on 24th of January 26, they released the vehicles. 24th of January 2026.
And my impugned order is 8 January.
Obviously, they delayed in compliance of the judgment. I can't, how can I be made responsible? IOCL चिट्ठी है ना? दे देगी. Now, this is the fresh work order of IOCL. You know, I have the letter with me. I can, if a lordship permits, I can just show it here. Those two vehicles were deleted from the work order of IOCL. This is the letter. So I'm sorry, I have not been able to file it. What is it? Dear, that's how we start the video.
Whatever I was just trying to give you, already work order has been issued.
Whatever be.
I'm just bringing to your lordship notice, Sumana.
Then again, suppression of fact. They have filed your counter. You are not saying that work order has been issued. Thus, see the kindly consider the oil company's actions. The suppressment them.
They file a counter.
But they have filed the counter on Friday. Very blood on
20th, not 20th.
on
On 20th.
20th of February. They are suppressing this.
What order is issued?
Kindly see the date. My other friend is now heading it over.
On 9th of January, I have.
Then it's a suppression of fact.
No, madam.
It's a suppression of fact.
They have not disclosed.
Not disclosed in the
I
counter.
have disclosed in the.
The work order has been issued.
No, they are saying the kindly see the language employed in the counter. Para 18, my lord. They are kindly see the language employed in the counter. Para 18. That upon cancellation of petitioner's allocation, high tank trucks earlier allotted to so were reallocated strictly in across. What is the meaning of reallocation, my lord? Reallocation. What is the reallocation is there in the tender notice? There is nothing called reallocation.
And substituting.
Whoever is employing a word which is not there in the tender notice.
No, January 9, 2026, they have said 3 names.
Reallocated.
Oh, whatever. That's the language.
They are not saying about the work order. This may be a letter of acceptance.
Subsequent allotment. So they have disclosed in paragraph. Not that. But they have. Next, I believe.
Subsisting contractual.
Reallocated in favor of so.
Oh, you should be choosy about a word.
Reallocated.
You understood that how it is to be taken. Reallocation means something different, and the allocation is something different.
Yes. Reallocation is in favor of a person in whose favor allocation was there. You are introducing 3 new persons.
Not new person. As per the ranking, they are ineligible.
Then
That's why I'm saying don't go by what the authorities say with the closed eyes. Please apply your mind while you draw.
Yes, madam.
The word reallocation and allocation are 2 different things.
yes, sir.
Anyhow, we will not go by the rigor of those words, but they have disclosed 3 names that show we have to go by it. The conditions are simply that whether it is a conditional or a conditional.
That's the limited point.
That same issue has been, the 2 writ applications are given, that is the.
Oh, that is different. We have to decide this.
It is my duty to inform your lordship and this submitting.
No, 4.
This matter relates to the detention of a vehicle belonging. And I would appreciate that the petitioner is the owner and consignor of the goods. Goods were moving belongs from Nagpur to Patna, and they took a route belongs through Orissa, that is Sambalpur. It was intercepted at a place called RAMAN in Sambalpur. And they, Lord, without giving adequate opportunity to the owner of the goods to come forward to appreciate the entire thing and to also produce the documents, they have assessed it as if the owner has not appeared in the goods, because there's a huge difference of penalty. The lordship will kindly turn to 129A and B. A is a much lesser penalty when the owner appears, and B is much onerous, an amount of penalty when the owner does not appear. So with the entire proceeding, the Lord, from 23rd, it was initiated detained. By 24th, my Lord, half the proceeding was completed. 30th, my Lord, they issue an order, serve it on the driver. And your lordship would appreciate that this particular reason, my lord, of violation of natural justice.
Why 129 and 129A?
No, I just, before that,
Your Lordship, because there is a stringent condition. Your Lordship, in
He says
20,
that so far as the owner is concerned, the conditions are a bit moderate,
Your Lordship,
but 129A is more stringent.
no, 129, 1B.
Is more stringent. He says that when I am available, you know that I am no owner and he is a driver. Then you could have initiated serve a notice of the owner.
Your Lordship, in fact, I have obtained the instruction, Your Lordship.
That's why you are available.
now, my lord, my difficult,
Your Lordship,
my difficult, my
Your
lord,
Lordship,
that now the goods are being put to auction. And my lord, may I just humbly suggest, my lord, they have now levied some 1 crore some odd on a notional rate, my lord. If your lordship kindly turn to page 25.
You deposited that without prejudice.
No, 1 crore some odd, my lord. Where, my lord, at page 14, I have at best, my lord, if their allegation is correct that there was no e-waiver, your lordship kindly turn to page 15, my lord. I am liable to pay, page 15, my lord. I am liable to pay, my lord, 5,78,550, my lord. I am ready to deposit that amount provisionally, subject to the result of the writ petition. Let the vehicle, my lord, because these are perishable items, my lord. These are areca nut dust.
Taxable value 57 lakhs.
57 lakhs. And the invoice is there, my lord. And your lordship would see how they determine, my lord, at page 25.
Only the waybill was not there.
So only the e-waiver was not there.
Not there.
And my,
That's
Your Lordship, for that
what
draft.
was there.
Your Lordship, he has submitted the invoice in the writ petition. Your Lordship, but the officer's allegation, the department's allegation is that the driver
Did not submit
not submitted the invoice.
but he is a
The
registered
invoice is
dealer.
there.
Both the consignor and consignee are registered dealer.
order that they will pay consideration, so we will give them a response by way of dividend and principally of a veritable nature. But there is somebody in the this much, the value is more, he has paid.
Your Lordship,
Both the vehicle and the goods, my lord.
the proper.
You will say that these are the invoices which we have shown. Only thing is that it was not produced. So the value is not disputed. So in that event, whatever is chargeable on the value will be charged. You deposit that amount.
Man, it's 5 lakhs,
They will
78,550.
test it out. Further undertaking. That in the event it is found that the invoice is also spurious, fabricated, they will definitely charge more, whatever they see. You have to give an undertaking.
And your lordship would appreciate, they will not rely on an internet price to determine